A boy named Marcus brought me a drawing 8 months after the case closed. He was 11 years old, and the drawing showed a hospital room with a window in it, and outside the window he had drawn a sun, small, in the corner. He said his mother had asked him to give it to me. I looked at it for a long time before I could say thank you. That image is why I am still talking about this case. Let me go back to the beginning. Her name was Diane Okafor. She was 38 years old the night another car ran the light at Maplewood Avenue and 5th Street in Clarkton, Ohio at 11:22 p.m. on a Friday in February. The roads were wet. She was on her way home from a 12-hour nursing shift at Clarkton Regional. The paramedics who arrived 7 minutes later found her with 2 broken ribs, a fractured collarbone, and a blood loss rate that one of them described in testimony as the kind that does not wait. She needed a transfusion. The hospital called Clarkton Community Blood Services. They delivered 2 units of O-negative blood inside 40 minutes. Diane Okafor survived. 3 weeks later, she received a bill from Clarkton Community Blood Services, LLC, $4,800, addressed to a woman who had not yet returned to work, who could not yet raise her left arm above her shoulder, who had a son who drew suns in the corners of things. I want to ask you something before I keep going. Have you ever been in a room where someone had the ability to choose generosity and chose something else instead, and you had to sit with what that choice cost another person? Subscribe, because that is exactly the kind of room this case put me in, and I want you here for what happened when I finally had the chance to respond to it. Subscribe now and turn on notifications so you do not miss a single story. The defendant was Gerald Foss, 54 years old, founder of Clarkton Community Blood Services 11 years earlier. I want to be honest about what I noticed when he came into my courtroom. He sat very still. He wore a gray suit, slightly too large in the shoulders, and when Diane's attorney was speaking, he looked down at the table, not to avoid accountability, or not only that. He looked like a man who had made a decision that had brought him somewhere he did not fully intend to be. I noticed that. I held it next to everything else. It did not change what I had to do, but it changed how I did it. Diane Okafor came in quietly. She sat down and arranged her things, her bag, her coat, a small folder, with the kind of careful precision that told me she was using order as a way to stay steady. She did not look at Gerald Foss during the opening statements. Not with hostility. She was simply not wasting anything on him. About 40 minutes in, when her attorney introduced the medical bills and the total appeared on the screen, she reached into her folder and took out a piece of paper. She did not read it. She held it flat on the table under both hands and did not let go for the rest of the morning. I found out later it was a note from her son. That is who she was in that room. Not broken, braced. Both of those things were true and neither one erased the other. Diane had filed a civil complaint under Ohio's consumer protection statutes, specifically the section governing predatory billing against individuals who received emergency services, and under a hospital pricing transparency clause that had gone into effect 14 months prior. In plain terms, Gerald Foss had a policy that applied emergency delivery surcharges to patients billed directly rather than through insurance. Diane's insurance had a processing delay from an unrelated claim dispute 6 months earlier. That made her a direct pay patient on paper. That triggered the surcharge, $4,800 for blood she had no ability to consent to paying for, received while she was unconscious, delivered to a hospital with no time to negotiate terms. He had applied this policy to at least 11 other patients in the preceding 2 years, 11 names, 11 bills, 11 people with no ability to say no. The thing that stopped me when I first read that file was not the amount, it was the timing. She had survived, and then 3 weeks later the piece of paper arrived. I was 12 years old when my father came home from the hospital after a stroke. My mother stood in the kitchen holding the first bill, very still, not crying. I remember thinking the worst part was supposed to be over. The paper said it was not. I did not put that memory in any document, but it was with me every day of those proceedings. If you are still with me, you have probably gone quiet. Whatever was happening around you when this video started has probably faded a little. Subscribe. That kind of attention deserves the rest of this story. Subscribe and turn on notifications. What comes next is where things began to shift. 4 days into the proceedings, Gerald Foss's attorney submitted a character witness, a woman named Loretta Sims, who ran the blood bank's community outreach program. She testified that over 6 years, Clarkton Community Blood Services had donated more than 900 units of blood to underinsured patients at no charge. She had records, names, dates. I did not expect that. It did not change the billing policy or what happened to Diane, but it was real and it belonged in the room. That is where the grace current began, not with Gerald Foss defending himself, but with evidence that he was not simply a man who had decided human suffering was a billing category. He had also genuinely chosen something good, and then separately chosen something that caused real harm. Both things were true. Both had to live in my courtroom. Here is what I am offering. The rest of this story, told the same way I have been telling it. Nothing held back, nothing resolved before it is ready, nothing softened because it is easier that way. Subscribe if that is what you want. I will keep going. The sorrow current ran hard from the start. The first document that established the full weight of what was lost was a financial impact report. Not just the bill, but 3 months of what it set in motion. Diane had taken a secondary loan to cover the charge while fighting her insurance delay. She returned to work 6 weeks after the accident before her physical therapist had cleared her. Her supervisor wrote, "Diane never once complained. I had to watch her carefully to know something was wrong." That sentence belongs entirely to the sorrow current. It describes what it looks like when someone absorbs a harm no one required her to absorb and does it quietly, without asking to be seen. The grace current came on day 2, in the form of a letter. Gerald Foss had written to the Ohio Blood Services Board 9 months before Diane's accident, requesting regulatory guidance on emergency billing. In it, he wrote, "I am uncertain whether current practices serve the patients we were built to protect." I wrote that down and did not let go of it. It told me something about him the charges did not contain, that some part of him had already been asking the question, that he had not acted on the answer. The letter was sent. No response came. The policy continued. That is the geography of how a person causes harm, not from coldness, but from the slow failure to do what part of them already knows needs doing. I just realized saying that out loud, that I had never actually put that geography into words before today. Subscribe. It is going to matter directly in a few minutes when we reach what I ordered him to do. Subscribe now. On day 3, Diane Okafor took the stand. She was composed. She answered every question with the same precision she had used to arrange her folder on day 1. Near the end of her testimony, her attorney asked, "What did you want from this process?" She was quiet for a moment. Then she said, "I want the next person in that ambulance to not have to worry about this." That sentence belongs to both Rivers at once. You only want that thing if you have felt the cost yourself. And yet it carries something forward-facing that sorrow alone did not produce. I wrote it down. Both things I had been feeling were in that one sentence. That was the convergence point. After that, both rivers were running together. I watched Gerald Foss when she said it. He looked up, not at her, at the ceiling briefly, the way someone does when absorbing something they have no prepared response for. Then he looked back at the table. In those 2 seconds, something crossed his face that did not belong to his defense. I know what it looked like. It looked like recognition. I want to stop here for just a moment, not for effect, because what I just described, a person in that chair recognizing something they had not allowed themselves to fully see, is something I have watched happen maybe a dozen times in my career. Every time I feel both things at once, the grief that it took this long and the specific hope that lives inside watching someone finally arrive somewhere true. I need a second with that. Subscribe while I take that second. Subscribe and stay, okay? Let me keep going. The defense was competent. The policy was legal under current Ohio billing code. The surcharge was disclosed in the blood bank's service agreements with hospitals in fine print. The 11 other patients had eventually received insurance adjustments. These are facts, and I held them. The defense also presented testimony from Foss's bookkeeper showing the blood bank had operated at a net loss for 3 of the last 5 years, and that emergency surcharge revenue had directly funded the free blood donation program. That is a genuinely complicated fact. The sorrow current was funding the grace current, inside the same organization, inside the same man. Not an excuse, but a truth the ruling had to account for honestly. Then Gerald Foss testified. He was measured. He explained the policy and the rationale. Near the end, his attorney asked if he had a statement for the court. He paused, longer than the question required. Then he said, "I built this organization to save lives. I am standing here because I also found a way to make saving a life cost someone something she could not afford. I have to live with those two things being true about me." I wrote it down. I looked at it for a long time. Both things I was feeling were in that one sentence. I did not expect that. Before the sentencing, I want to tell you one more thing. When I was 31, my younger brother was in a car accident, not as serious as Diane's, but serious enough. He spent 4 days in the hospital. When he came home, he healed mostly. But for 6 months after, I noticed something in him I could not name. He was careful in a way he had not been before. Not fearful, careful. Like someone who now understood that the world could reach into an ordinary Tuesday and change everything, and who was living with that knowledge without talking about it. I did not ask him about it enough. I wish I had. When Diane Okafor walked into my courtroom, I recognized that carefulness in how she organized her folder and how she held her son's note. She was carrying something not visible on any medical chart, and she was doing it with a steadiness nobody had required of her. I placed that memory next to this case. I let it sit there. You just heard what I said about both things being true about Gerald Foss, in his words and in mine. I want you to hold that. Subscribe before we go further, because what I said to him in that courtroom, and what happened after, is the part of this case I have thought about the most. Subscribe now. The room before sentencing was very still. Foss sat with his hands flat on the table. Diane had her folder closed, eyes on the wall near the window. My hands were on the bench. I had spent 3 evenings rewriting the terms, not because I was uncertain about the outcome, but because I wanted every part of it to carry both rivers. I had decided knowing this ruling had to hold the weight of what was lost and leave room for what might still happen. Those two things do not always fit in the same ruling. In this case, they did. I had made sure they did. I found Gerald Foss liable on both counts. Then I turned to the sentencing. I am ordering you to pay full restitution to Diane Okafor in the amount of $14,200. The original bill of $4,800, the loan interest she paid while disputing it, and the income she lost returning to work before she was medically cleared. This money is owed to her as a return, not a penalty. She paid a cost she was never supposed to carry. It comes back to her. I am also ordering you to identify the 11 other patients who received emergency billing surcharges in the preceding 24 months and contact each one in writing within 45 days with a full refund of any amount paid above standard service rate. You will provide this court with documentation of each contact and each refund. These 11 people also carried something they were not supposed to carry. The weight comes back to them too. I am ordering you to submit your billing policies to an independent patient advocacy review board within 90 days and to amend any policy the board identifies as treating emergency conditions as a billing escalation trigger. You wrote to the Ohio Blood Services Board 9 months before this accident asking whether your practices served the patients you were built to protect. This order is the answer to that question. And there is one more thing. For the next 18 months, you will serve as a pro bono financial counseling resource for patients at Clarkton Regional who receive large emergency bills without insurance clarity. No fewer than 2 patients per month. You will not direct them toward any product or service of your organization. You will sit with them and help them understand their options. You can complete this in 12 months instead of 18 if you establish, in collaboration with Clarkton Regional, a written emergency billing patient rights disclosure given to every emergency patient within 24 hours of admission. That document will carry something forward that no fine alone can carry. I believe you know how to build it. That belief is in this order. Let me say again what I said to him in that courtroom. What you did was specific. You built a policy that treated the moment of someone's greatest vulnerability as a billing category. Diane Okafor paid for surviving with money she did not have, with weeks of work she was not ready to return to, with worry carried on top of recovery. That is real, and it was caused by a choice you made and did not revisit. To the people who were harmed, you were not supposed to have to fight this hard after surviving something that hard. The record of this court holds your names, and everything ordered today exists because what happened to you was wrong. To Gerald Foss, you are not only this, the letter you wrote, the 900 donated units, the look on your face when Diane spoke, none of that belongs to the charges and none of it is erased by them. Both things are true about you. This sentence is designed to let you live in that truth and do something with it. To everyone in that room, what we do when someone is at their most exposed, unconscious, unable to consent, unable to negotiate, says something about who we have decided to be. That is not a legal principle. That is a human one. And this is the fact that contains everything I felt about this case. A woman carried into an emergency room on a stretcher came back into a courtroom on her own 2 feet and said she wanted the next person in that ambulance to not have to worry. She wanted something larger than what was done to her. That is the most important thing that happened in that room. As the courtroom emptied, I stayed seated. I watched Gerald Foss fold the single sheet of paper in front of him slowly and place it in his inside jacket pocket. I do not know what was on it. I know he kept it. When the room was empty, I put both palms flat on the bench and held them there before I stood. Both rivers were still running. I held them there until they settled. On October 14th, 7 months after the ruling, I received word that Clarkton Regional had formally adopted the emergency billing patient rights disclosure that Gerald Foss had helped draft. 2 pages, approved by the hospital's Patient Advocacy Board, given to every emergency patient within 24 hours of admission. On that same date, Foss submitted documentation showing all 11 patient refunds had been completed. I sat with both facts at once. The sorrow was still present. 11 people who should never have needed a refund, a woman who should never have needed a lawsuit. The grace was also present. A document that would now sit in a hospital room with someone frightened and unguarded and tell them their rights before anyone had the chance to take advantage of not telling them. Both rivers. Same moment. The ruling was not appealed. The window closed on day 31. My response was not relief exactly. It was closer to the feeling of setting something down after carrying it a long way. Not because it was too heavy, but because you have finally arrived somewhere it can rest. This case showed me something I had not understood clearly before. I had thought the hardest rulings were the ones where the facts were unclear. This case showed me the hardest rulings are sometimes the ones where the facts are completely clear and the person in front of you is completely human, where the harm is undeniable and the person who caused it is genuinely more than the harm they caused. Holding both and ruling from both simultaneously is the work. I have watched enough times to trust it that people who are seen fully, not only as what they did, respond differently than those seen only as a category of offense. To anyone who recognizes the sorrow current of this story, who has been handed a bill at the worst moment, who has carried a cost no one required you to carry, I saw it in Diane Okafor's face. I saw it in how she held that note. The weight is real and it is recognized, and the sorrow did not have the last word in her. She came in organized and steady. She left with a court record that held her name, and her son drew sons in the corners of things. Both of those were true at the same time. To anyone who recognizes themselves in Gerald Foss's chair, who made a real choice that caused real harm and is now carrying the question of what comes next, the people I have watched move towards something after that chair are the ones willing to use the knowledge of what they broke to make it harder to break that way again. What distinguished them was not the size of the harm, it was the honesty they were willing to carry. The recognition that crossed Gerald Foss's face when Diane spoke, that moment is where the next chapter begins if you let it. If you want the others, subscribe. The comment section below tends to gather people willing to feel two things at once. That is a specific kind of person, and they are worth finding. Say something true down there. Someone will be glad you did. Diane.